living rent-free in your heads again, huh? I mean, if you're gonna spend your days obsessing over me, you might as well start calling me something respectable. Maybe Daddy Shizzy, or better yet, Papa Nut. Who's the grown-up here? Alright, it's me. Let's go. Call me Daddy, yeah, that's who I am. Running your mind's like a master plan. Papa Nut, Shizzy Daddy, take your pick. I'm rolling in your thoughts while you still act sick. Call me Daddy, it's what you mean. Why you chase the crust and I take the lead? Living rent-free, that's my name. Go ahead, say it, put some respect on the name. Man, I'm too old, well here's a surprise. I'm the one with the brains while you're stuck with the lies. You act like you're experts, but here's the reality. I'm the one controlling your mental reality. So while you're out there trying to throw shade, I'm sipping coffee and you're feeling betrayed. You're mad, I got the spotlight, now it's my time. So why not call me Daddy or Papa with a rhyme? I'm the landlord and you're just the tenants, stuck in your headspace with no insight, no repentance. Call me Daddy, you know it's true. You'd be lost without me, stuck in the glue. Call me Daddy, I'm holding your mind while you're scrambling, trying to find what's behind. Papa Nut, Shizzy Daddy, don't you see? You're living in my world now, I'm the VIP. Call me Daddy, just let it be. While you're trying to figure out your own identity. Oh, I see you're confused, trying to get it right. Spinning your wheels while I'm out of sight. You think you've got it figured, but you got it all wrong. I've been running your minds all along. But sure, keep pretending you don't care. Keep saying you're done, but I'm still in the air. You got no choice but to bow to my name. Daddy Shizzy is here to own the game. You say you don't watch, but you're obsessed. Every word I say puts you to the test. Call me Daddy, Papa Nut, you know you should. Because I've been living rent-free, and you know it feels good. Shizzy Daddy, owning your headspace, and there's no escape. Good luck with that.
Oh my gosh, everything is all messed up over here. It's so wonderful. It's a mess. Emma Washington, thank you so much. Early mug raid. Hello, how are you? I am good. And I've got somebody sent me something, a nice little package in the mail. We'll have to see that a little bit later on. I mean, it's probably something good. All I know is whenever I shake it, see, I don't know what it could be. Could be anything. We'll have to see it. It could be some crazy stuff. I don't know. We'll just have to see. I hope they give P.O. Box the flick. It's gonna be good. If it's not ticking, it wasn't for me. No, it's not from you. It's from somebody else, and I'll name them later. I don't know. Oh, I hadn't thought of that. It might just be Pippa. It could be anything. Oh, no, it's not ticking. It just makes a rattling sound in there. Maybe it got broken. You never know. No, I never know. Yeah, P.O. Blockman chat was no fun. Oh, sorry. Oh, I have so much for you today. And well, why don't I just let you guys hear this song I've been working on? I think it's good. We'll see. You tell me what you think.
He talk like a thug in a $50 suit, but that tie can't hide what the snakes produce. Defame, delay, then sue for for the show.
This one's for the paper gangsters out there.
He got a law degree and a grudge to match. File a lawsuit every time his lies get scratched. Talk slick in a blog, then duck when it lands. But he ain't got a case, just a scam and a plan. Pushing false claims like it's just routine. Call it slander, but the facts too clean. Taking shots online, then playing the victim. Crying to the judge when the truth finally hits him. Seize and resist, he a fraud with a twist. File threats when the lies get dismissed. Can't take heat, so we run to the court. But that briefcase ain't nothing but sport. He scammed, got caught, now he litigious. Trying to flip the script like he religious. They defamed, but the facts don't bend. Truth got a way of circling back in the end. He the type to gaslight and redact receipts. Trying to bury folks under legal deceit. Courtroom soy boy, all bark, no wind. Tossing lawsuits like a coin in the wind. Pulling strings behind sock accounts, but the paper trail don't lie, check the amounts. He sue, he smear, then cry when he fall. Only thing he's practiced, ducking that call. Seize and resist, he a fraud with a twist. File threats when the lies get dismissed. Can't take heat, so we run to the court. But that briefcase ain't nothing but sport. He scammed, got caught, now he litigious. Trying to flip the script like he religious. They defamed, but the facts don't bend. Truth got a way of circling back in the end. He don't want justice, he wants silence. He don't want peace, just compliance. When the smoke clears, who's standing tall? Not the clown with subpoenas trying to sue us all. Yo, he filed for clout, not cause he got hurt. Call it injury, but he just want a t-shirt. Talking about damage, acting all shook. But he write half his claims from a group Facebook. Claiming harm while he throwing stones. Then wonder why nobody answering phones. He a scam in a suit, man, nothing more. Trying to weaponize the law like a petty little war.
You can't sue away the truth, no matter how many motions you file. Real talk don't need permission. It survives discovery.
Oh yeah.
Got caught, now he litigious. Trying to flip the script like he religious. Say defamed, but the facts don't bend. Truth got a way of circling back in the end.
Oh, yeah, I like that. That was a pretty good one. Number 124. Good evening, everybody. Welcome, welcome, welcome. I thought you guys might like that one. It was a pretty good one. And yes, I did see there's a new filing. It's going to be interesting. Cajun Bayou Queen. Oh, yeah. Good to see all you fine folks. Man, oh, man, oh, man. Clever song? Yeah, I've got another one, too. Just wait till you hear that one. That one's going to be really good. Yeah, I've been a little busy today. I came up with, I was sitting around and I'm just like, you know what? I think there's a song right here in this. And that's what I did. I put that one together, made it really nice and solid. Hope you guys enjoyed that. I've got some pretty crazy stuff tonight because the Bubbles, he just loved papering everything. He could not help it. He papered. I mean, if let's put it this way, if he would have been around during the whole pandemic, you never would have ran out of wallpaper because there was plenty of it around from him. Yeah, I think I need to go lick a window. That's what I need to do. Share the screen here. Let me show you what we got here because this is gonna be crazy stuff. Give me a second. I gotta move this over here. There we go. And I'll pull it. I gotta zoom in on it a little bit because, well, I didn't do that to start with. It helps whenever I do that. Now, this particular document was filed a little ways back here. This was the order that was put in by the judge. This would be document 125. This matter before the court defendant's notice, defendant's counsel inability to appear on April and request to decide motion 96 and show cause based on 115. Well, and then I went back and I was like, well, 96 is Jeremy Hale's through underside. He's motioned for sanctions, including judicial default. And then 115 would be this one, right? I don't have 115 pulled up. Well, I'll be a son of a buck. I thought I had 115 pulled up. Give me a second. Well, it doesn't matter because if I'm not mistaken, 115 got discarded. But I'll pull it up anyway. Give me just a second. Open file location there, because that's sort of one of the important ones that I had pulled up for you. Open file location. Duck on it. All right. Let me get that one up. I thought I had all these things lined up, but of course I didn't. Let's see. 115. And 115 would have been this document right here, which was the motion for response to motions for sanctions for doc number 98. Well, that document was filed today. Document 124 was filed today. To the extent defendant's counsel seeks leave not to attend the hearing that was scheduled nearly 3 weeks ago for tomorrow, April 3rd, 2025, request is denied. Similar to the extent of filing a request for continuance or stay of the hearing scheduled for tomorrow, the request is denied. The hearing will go forward tomorrow as scheduled. Now, yesterday, defendants filed a motion to consent to magistrate 123. Defendant's current motion 124 makes reference to the possibility of stay being issued by the district court in response to doc 123. Now, this starts getting really confusing. The court would note that no stay has been issued by the district judge. Merely requested stay does not excuse noncompliance with the with this hearing. Hearing this case was noticed nearly 3 weeks ago, Doc 99. Thus, defendant's counsel had more sufficient time to make travel arrangements. Moreover, defendant's counsel had ample time to file a motion seeking a continuance of the hearing if there were a true scheduling conflict. Instead, he waited until the 11th hour. Defendant's counsel has filed plenty of other documents, which we will see, which would be all 100, 104, 105, 111, 112, 114, 115, 116, 117, and it would be this document, which was a motion to strike 96, another motion for attorney's fees, another motion for attorney's fees under this one, another motion for dismissing counterclaims 2 and 3, and another one for request for leave, another one for motions attorney's fees under this one, another one for motions attorney's fees under this one, another one for motion to dismiss. Yeah, that right there, the judge said, well, because defense counsel has complained about needing to travel to Florida for this hearing, the court would point out that defense counsel chose to handle the case pending in Florida. Thus, he should have anticipated, which he couldn't do because he's a complete stating that the parties chose to appear in this district knowing that it was across the country. They should expect, well, of course he expects it, but that's not the problem. The mere filing of the motion to stay does not excuse noncompliance with court order. Spend time to travel to Florida for court appearances, then he should not have entered an appearance in this case, ever. Well, but see, that's the problem. Is because he believes he's entitled to file anything that he wants to. Welcome, welcome, early Raiders. Welcome, welcome, welcome. And I will be opening up something that came in the mail to me later today, later in the stream, probably before the next letter. The letter's going to be last. And when the court sets a hearing, those lawyers get on a plane, or in other words, get your happy ass here and get here. That's part of the deal when a lawyer decides to take on litigation. Now, so show cause based on 115 is denied. So 115, you can just kiss its happy ass goodbye. It goes away. 115, bye-bye. 115, request to decide motion 916, show cause based on 115 is gone. Now, 117, he still hasn't heard on that. Let's see, he's got 115 right there. It's denied. It right there is completely denied. Yeah. And whenever you get to these other ones, Oh, it gets worse because the judge, he didn't like that one either. And this is the exhibit to 23-1, which is an entire like pleading itself. It goes on and on and on and on. And then we also get over here to motion strike 96, which will most likely be denied because, well, that one, he never showed up to the hearing for that. Motions for attorney's fees is probably going to be denied. 105 is probably going to be denied. 111 is probably going to be denied. 112 probably going to be denied. 14, 15, 16 will probably all be denied. Now, whenever you start papering the court with things like this kind of stuff, the judge doesn't appreciate it. As he showed right here, the matter was scheduled for show cause hearing. Document 99, prior to the hearing, the court notified counsel for both parties the following issues would be addressed at the hearing. Whether defense counsel's pro hoc status would be revoked, whether counsel for both parties should be sanctioned for the filing of specific motions that were frivolous. 96, 98, 118. Paradoxically, the defendant's counsel failed to appear at the hearing that was scheduled, in part for him to explain why he should not be sanctioned for his unprofessional conduct. Me, Ray, welcome Megan Fox. Oh, we got something good for you tonight, sweetheart. Oh, we've got something really good for you tonight. Expert is on also. That's awesome. I love it whenever Expert is on. He's one of my good friends. Megan says hi. She did say hi. Megan Raid. Welcome, Megan Raiders. Now, defendant's counsel was clearly aware of his obligation to attend the hearing, and we're about to show how crazy it gets because this is something common with this boy. Defendant's counsel filed a notice informing the court his decision not to attend the hearing. Well, the court issues an order shortly thereafter, making it damn well clear that you better bring your happy ass here, and it's going to go forward that he was expected to attend. And then, less than an hour before the hearing was scheduled to begin, defendant counsel filed a notice of withdrawal as counsel. The mere filing of that notice, of course, did not relieve defendant's counsel of his obligation to appear at the scheduling hearing. Nonetheless, defendant's counsel failed to bring his happy ass here. Denied, but not by Megan. Fix and chat. Well, Planet Lupa, good to see you. Oh yes, and I've got a nice gift here that's going to be opened up. Someone was kind enough to drop something in my P.O. box. And all I know is it rattles, it doesn't tick. So that is going to be a pretty sight to see as soon as I open that thing up. And I'll also let you guys know who it was that sent it out to me. Oh, yeah, they gave me permission to use their name. Shizzy, it's good to see you. It's Georgie, formerly the Will Burns. I revamped the channel. Well, good to see you. Glad you did that. Good to see you. Had to change my shoes. Oops. Fox, of course. Yeah. Megan Fox. I like the Megan Fix. I like that one. That one's pretty good. I need my fix. Give me my Megan Fix. Less than an hour before the hearing was scheduled to begin, defendant's counsel filed that notice. Well, the hearing went forward regarding whether plaintiff's counsel should be sanctioned. Now, this is just for the plaintiff. Filing Docs 85 and 86. After a hearing from the plaintiff's counsel, the court thoroughly explained on the record that Docs 85 and 86 warranted sanctions because they were filed without sufficient legal and factual basis. The court explained that it believed an appropriate sanction would be $2,000 per filing for a total of $4,000. Under those local rules, an attorney may not withdraw without permission from the court unless the client has another attorney of record who intends to continue the case. Defendants do not have another attorney of record in this case. Therefore, defendants' counsel can't withdraw their happy ass unless given permission by the court. Such permission has yet to be granted. Well, you think that he's going to allow that to stop him from doing whatever the hell he wants to? Oh, just you watch. Just you wait and see. Because he has until Wednesday to respond to this. And if he doesn't respond, well, what do you think that judge is going to do? Heard there's a new doc in a Fed 2 case. You talking about part deuce, the Fed case part deuce. That is pretty damn clear. There is some crazy stuff going on there. And we'll be going over that tomorrow night. So I haven't had a chance to read it, but as soon as I read it, oh, I'll be going over it. Don't you worry. Going over it. I might have a new letter. You'll never know. You never know what'll happen. Check the email you sent to me. All right, I'll check it whenever I'm able to. Thank you very much there, Georgie. Appreciate you. I forgot where are my manners. Hello, everyone. How are y'all tonight? Oh, they're so good. Now, the defendant's counsel failed to appear at the order hearing on April 3rd. Court hereby orders defendant's counsel to show cause as why the court should not exercise its inherent authority and sanction him for failing to appear. Do you think sanctions matter to him? And we'll get into that here shortly, explaining that before issuing sanctions under its inherent authority, a court is required to allow an attorney opportunity to respond orally or in writing. The show cause response is due by 5 p.m. on Wednesday, April 9th. 5 p.m., April 9th, 2025. So ordered the 4th day of April 2025. Now, I will say that is amazing to me. And that may end up being tomorrow's, which I'll go over to. It'll be a Rumble exclusive. I've got something that I can only show on Rumble. And whenever I show it, I guarantee you over here, they would come after me. Over there, it's called fair use. Let's see, they have problems over here on the YouTube. Let's put it that way. That's the last thing we want to do is get slapped around like the wet piece of paper that I am. Yes, motion for sanctions was giving them problems, including judicial refault. Well, now, whenever we get to this next part, I just want you to know that there will be a letter following it, and it's long. BBB will flee the country to Albania tonight. We learned he has done this before. Oh, he's done lots of stuff before. Mike Morgan, we know that for sure. Buck Naked with a $2 super chat. $100 for a propeller on top of the helmet. I like that. No, I might fly away if I put one of those on my head like that. You know what I'm talking about? Yeah, it might just we all float away. That'll be what happens. That'll be exactly what happens. I'll just float away into the, oh yeah, 2014, I think. I got a good song. Get it. It's still a good song. Oh yeah. So what I have here is his shenanigans. His shenanigans here. So buckle up, get ready for it. It's gonna get really good. Here we go. Bruce Zemaskin responded. Now I did filter out some of the names and emails on here. Tug on Megan. It takes them 3 hours to read 2 pages. I get lost along the way. Live from over at Rumble. Well, good to see you, Sir Frank, over at the Rumble side. Welcome, welcome, welcome. Yes, I do stream over there, but like I said, it won't be tonight. It may be tomorrow, and I'm going to be going over something that I can only show on Rumble. So just know it'll be tomorrow. Tonight is this one right here. I've been waiting to get into this one for a while. Pursuant to practice book 2-35, disciplinary counsel asserts the following allegations of misconduct as to the deuce, the bruise, the main skin. Hereafter responded. The respondent committed professional misconduct, including violations of Rule 4.4 of the Rules of Professional Conduct. Rule 4.4 provides, in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such a person. It's amazing. Hasn't he done this already? Respondent, while acting as his own attorney in this matter, has repeatedly used means in media, social media, and in communications with the Office of Chief Disciplinary Counsel, statewide grievance committee, and grievance panel, counsel that has no substantial purpose other than to embarrass and or burden as set out more fully below. That conductive involved multiple individuals and clearly had no substantial purpose other than to embarrass and or burden those individuals. Oh, who is this filed by? Oh, this is part of the grievance committee. Yeah, this right here was disciplinary's counsel. The disciplinary counsel wrote this. This is the counsel. And this would have been filed back in 2020, 2024. Yeah, 2024, I believe is what it was. But we'll get into that. Pay attention. First, there can be no doubt that the respondent has been representing himself throughout this entire process. First, during the probable cause determination, he drafted, signed, submitted an answer on his own behalf. Next, during the probable cause determination, he frequently sent emails to grievance panel counsel Gregory A. Benoit, making substantive arguments regarding Fed 2 is filed as informed definitive statements. Yeah, well, Jeremy has 21 days to amend his complaint against MLS. We'll see. I'll go over it tomorrow, Megan. It's probably not very long anyway. He frequently sent emails to grievance panel counsel Gregory A. Benoit. But if you want to come on here and talk about it, you're welcome. I've got somebody hanging out right now. Just guess what? They're reaching over, gently massaging my neck, shoulders, because my neck and my shoulders, because they're feeling so sore. But it doesn't do me any good.
Hey, what's going on, everybody? You know, when you talk to me like that, it was reminding me of Megan and Tug's stream a little bit ago. I think her husband should be sick more often.
Yeah,
I was almost there a couple of times. Whoa.
I mean, she was just right up on that mic and just whispering into it so softly. Just like some hard.
Yeah, some hard. That was hilarious. That was funny.
Annoyed. No, we weren't annoyed. We were quite well enjoying that, Megan. I had to go back and rewind it a couple of times because it got messy over here.
I was so excited.
Oh, no. Hey, boys. I think I sound ridiculous. Oh, my gosh. Oh, yes.
Men are so gross. Whatever.
We try. Now, that's an intro. Oh, yes. You know that he is.
I wasn't sure if we were doing a letter tonight or not. I wasn't sure if you
I wasn't sure if I was going to have it done in time because I was putting this thing together and I was just like, it's just not wording like I want it to. Words so difficult sometimes. Thank you so much for that, Emma. Now that's an intro. Oh,
well,
I'm
it's hard
working
for
on
me
a
to
new
stay
one
in
for
touch with that. I mean, you don't call, you don't write. I'm not a mind reader. I don't know.
You were just here last night. Last night got spicy, buddy, with Mo.
That was funny.
That was so much fun.
Funny. Yeah.
Ah, yes. So, and now this is that grievance hearing, and this is part of the grievance hearing. This was filed right here. Disciplinary counsel's additional allegations of misconduct. So, not only did he have a grievance against him, but he was making substantive arguments regarding the grievance complaint's claims, to which Attorney Benoit responded with substantive information, discussed the position of the panel with respect to the ongoing probable cause determination. Attorney Benoit also engaged with respondent in basically saying, I talked to this mother effer a lot. Position concerning the legal issues underlying the grievance complaint. For example, on September 14th, in response to an email from respondent stating, among other things, I'm receptive to learning your position as to whether or not I guess he meant the email exchange met all of the requirements of Rule 1.5c. Of course, respondent continued to represent himself even after probable cause was found. That email is part of the record, and we have all those emails. You have to understand, this is 64 documents. 64 evers of all of the shite that he was up to. This is just a grievance committee.
Yeah. What color?
And I mean,
surprised?
now I did start reading this one night, but I wanted to get down to these emails because as you can see, we're getting down to page 11. I mean, it says page 12, but it's actually page 11, and basically says to certify this document is emailed, delivered electronically or non-electronically to Ducey and Donato Rinaldi. Okay. Now, this is where he gets into his BS. And this is from July 22nd, 2023. Now, do you think he's changed much in the past couple of years, dear Mr. Bentley?
I'm thinking no.
But see, here's the good thing: is you get to be my respondent in all of this too, because I'm going to say Brucey's part, dear Mr. Butler. I appreciate your diligence in ensuring against the unauthorized communications with the represented party. As you note, I've been communicating substantively after engaging with Attorney Rinaldi in the absence of an appearance form with a checkbox indicating the nature of the appearance. You may consider Attorney Rinaldi's acquiescence in my openly communicating with your office and the OSBC as reflective of his and my, we assumed, your understanding that he appeared in addition to myself. In addition to the bullet points of my prior emails, we would also include a reply that I engaged counsel in reliance on your statements that, if I did, inform of specific factual basis constituting misconduct, as well as explain what nature of my communications resulted in your decisions to require all communications being freaking writing. I still hope that you might prevail upon once and for all to dismiss this rather than have to defend your own actions. If not, we'll file a reply. Thanks and have a nice weekend. Brucey. Good morning, Attorney Rinaldi. I write to inquire as to... Oh, that's for you. Sorry.
I was going to say.
Yes.
Good
You
morning,
can use any
Attorney
voice you want on
Rinaldi.
this one.
I write to inquire as to whether or not Attorney Matzkin is co-counsel with you on this matter. That is, does he still have his pro se appearance on file, or was you wow, that threw me off. On file, or was you appearance in lieu rather than in addition to? Attorney Matzkin has consistently communicated directly with my office and SGC throughout the process, including multiple times concerning matters of substance before and after you filed your appearance in January. Attorney Matzkin's email of 2:10 a.m. today attached is but one of several examples of his direct substantive communications with OCDC. There are many to SGC as well. In fact, he states in the attached email, I ask you to please file a consent to dismissal rather than requiring me and Attorney Rinaldi to prepare and file a reply to your opposition. Emphasis added. This seems a clear indication that Attorney Matzkin is and has been representing himself, within his rights to be sure, from inception of this matter through your filing and appearance and at present. I ask because, among other things, if Attorney Matzkin still has a pro se appearance in this matter, I will include him on all further communications from me. Confirmation of whether or not Attorney Matzkin is required for me to respond directly to his emails and to CC him on for future communications to your SGC. I will also update my certification page to assure proper service of all filings. I am CCing Attorney Matzkin as a courtesy for this email only. Unless and until OCDC receives confirmation of Attorney Matzkin's status as representing himself in this case, all communication will be directed to you only. Thanks. Douglas H. Butler, Assistant Chief Disciplinary Branch. Okay, fine. I don't even get to read my damn titles.
Okay.
No,
that's fine.
too late.
That's fine.
No.
That's fine. Well, and then in Exhibit 2, this is from Brucey again. Dear Mr. Bowler and Mrs. Rowe, Miss Rowe, ACDC, nice band, but Doug Butler, ECC here, would not apprise me of the specific basis for pursuing the misconduct based on the Jones retainer agreement, other than to send me Benoit's PC report and started all this may be too vague. I ask for a specific deficiency which constitutes misconduct. What needed to be in there? Or what was in there that should not have been? I have no idea. I don't know what I did wrong. Doug did clearly explain his right as AC/DC, great band, to go fishing for misconduct, not raising a grievance or PC report. Thus, his demand to see my current Connecticut contingency fee agreement, to which I promptly, within 5 minutes, responded. I reviewed the procedures in the practice book. It's a lot of sections and a lot of reading, and I don't know how to read very well or actually absorb what I'm reading, but it allows a dismissal by the SBC without being sent to SGC panel at all. Am I misreading that? If not, then it would seem that someone in SBC's office initially determined that this does not fall under all of these codes. I think it falls under all 3 of those grounds for summary dismissal. The grievant did not even check off a box for type of complaint. Do I get to know who reviewed the complaint and decide not to process it under the subsection and what the rationale was? May I have a copy of whether it was written in the record? Oh my gosh. If it was not reviewed by dismissal, why not? How does the Office of SBC determine which grievances to review for dismissal prior to forwarding to the SGC? Did whoever reviewed this take the note that Benoit's report states that there was no $500 fee mentioned or agreed to, even though I provided with the email showing the client explicitly acknowledged and agreed to a fee? To this day, nobody, Benoit, SBC, no Doug Butler has told me the specific basis it was misconduct at your fee agreement. All I have is this. It may be too vague in the opinion of a small claims court collection lawyer who ignored my freaking calls and my freaking emails for 2 months. He never spoke to me and then wrote a glaringly error-laden report that misspelled my name. How can you misspell Deuce? It's not D-U-E, it's D-E-U. 26 years after a clean record, 26 freaking years after a clean record in 2 states and never sued, I am beyond dismayed. I have to waste so much time taking for my practice my two clients and my family, and stress on such a clearly meritless complaint by someone who obviously filed the grievance to avoid paying a $500 retainer fee. I'd greatly appreciate responses to the questions here. Brucey. And then, of course, he writes this horrible letter about being prosecuted, about being held, just after 26 years, basically the same thing that he wrote to the attorneys that were handling his grievance complaint. Now, this is right here is what got him in trouble. As you can see, it's very long. I'm not going to read through the whole thing. But then on December 22nd, 2022, email to then statewide bar counsel Michael Bowler, chief disciplinary counsel. Again, he starts bitching and moaning. Dear Mr. Bowler, Mr. Staines, Mr. Butler, you all know this grievance was dismissible. It had to be dismissible under the summary dismissal. And you all know Mr. Butler is literally making up language to change the meaning of a rule to support a charge he invented that was not part of the grievance, and in fact in which the PC panel explicitly said it was not issuing PC. It accepted my position. No cost. Mr. Butler's prosecution for a charge which is address what possible logic is there for a rule requiring a fee agreement to state there would not be any cost, none, and that's why the rule doesn't say or require that, not without adding the language Mr. Butler did. Putting aside all the other questions about your officer's decision to pursue this against me, does ACDC, great band, have the authority to add words that changes the meaning of the rule? Oh, I'm going to put this in red highlight because it's so important, and it's so important that I'm not going to read it. If the answer is no to either, then Mr. Butler is exceeding and abusing his authority. This is a glaring and obvious in all of it's documented. Mr. Staines, on my panties, you have supervisory responsibilities. He could file a motion because there's no probable cause of a violation. At least that would end my continuing harm this is causing me to my practice, my clients, my family. You don't seem to be considering this. Doesn't this sound familiar? This is the same thing that he's been saying. My practice, my clients, my family. In response to my attempt to confirm it, there's no mention of costs in this fee agreement. It's going to be the charge of misconduct before the SGC if you come up with new charges. Well, Mr. Butler responded undetermined. This is incredibly abusive and portentous. Mr. Butler intends to conjure up all new charges not even thought of. Given that one based on made-up language is baseless, I don't know why I'm being targeted this way. I ask that all of you maintain all electronic records, handwritten notes from any privileged deliberations or any other communications related to this proceeding, as well as each assistant attorney and staff in both the offices. I don't know if I can read the next one. Do you want to try? That's very stressful on the voice.
Good morning. I hope both you had a nice Xmas and enjoyed your family time. Oh, I hope you both. God, I am cross-eyed tonight. Mine was less joyful. Given the upsetting continuing threat Doug is posing to my clean professional record, the impact it has already had on my practice and my life, and what's portended from his actions and statements, especially his indications that he'll formulate new, yet to be thought of charges. In case you've lost perspective, what you do is serious. Your actions have a major impact on the lives of lawyers who are trying to run their practice, earn a living, support their families, even when they've done nothing to warrant the charge or the prosecution. I know that you know this is nonsense. What I don't know is why you are doing this. This is my livelihood, my life. I'm starting to cry. It's inexplicable that you would think I'd stand by while you try to harm me, rather than challenge your actions when they are so glaringly abusive and in excess of any authority or rational basis. As ever, I invite you to disabuse me of anything below and what? of anything below in red that's incorrect, or I will offer them as admissions. And as ever, I invite you to call me on the phone. I even invite you to record the call, and even call me when I'm in Armenia. Doug repeatedly misinformed me in writing that there is no procedure for him to ask for dismissal based on no evidence of any rule violation. He may do so under 11A, A1. Doug repeatedly misinformed me in writing that regardless of any disposition agreed to or otherwise, including a dismissal with condition, there is no way to avoid traveling for the live SGC hearing.
Yes.
This was in response to me complaining of having to waste a day and risk travel.
But would it be wasting a day? I'm serious. Would it be wasting a day and risking travel? I mean, he's color coding again. Yes, yes, Megan. He color codes quite a bit. It's whenever he breaks out the rainbow flag, he just has to whip them colors all into place.
Yeah. See me, hear me. Maybe I should just read it like that. In fact, I may seek to attend by remote video. Number 3. 3 snaps up and a twist. Doug, on December 16th, requested a copy of my contingency fee agreement for CT clients in order, as he put it, to determine what, if any, disciplinary is necessary. Discipline, whatever. Spank me with a leather whip. Thereafter, he did not base any determination. I'm just going with it. I don't care anymore. Of a charge on what I provided in response to his request. The charges he conjured up has nothing to do with the sample I provided. When what I provided would not support a charge, he invented one based on the Jones fee agreement. Further, to number 3, using formal logic based on Doug's statement. Premise number 1. Doug's words. As he whispered in my ear. A copy of fee agreements is needed to determine what, if any, disciplinary necessary. Whatever. Premise number 2. Implicit from premise 1. The agreement at issue in the grievance does not lead to a determination that discipline is necessary. Oh, spare the rod, spoil the child. Otherwise, Doug wouldn't have requested one under Rule 8.1, according to his own words. Stop it, I'm trying to sell this. To determine. Premise number 3. The sample fee agreements provided have no basis for a charge in violation. Implicit as demonstrated by the fact that you did not base a charge on them. Conclusion. Therefore, neither the fee agreement underlying the grievance or the one you sent in response to my Rule 8.1 request supports and my 8.1 is bigger, supports a charge of discipline. Oh, wait a minute. No, it's not. Oh, there's an 11. From this, the only course is a Rule 11A, A1. Well, that's even bigger. Motion filed by Doug. Yet his actions defy the conclusion of the above syllogism. How long does this rambling go on? I'm making myself faint. Doug's purported charge is based on him first adding the words, or not, to change the rule's meaning. Then trying to erase his acknowledgement that the rule has written does not require me to mention I'm not even understanding what the hell I'm reading. His cost. His first letter will, of course, be an exhibit. Doug objects to the SGC being told a difference. Objects. Yes. Oh, it's objects. whether or not through professional expert grammar articles. You don't know shit about grammar. So apparently his strategy is to A, add to the words to the rule, or at least pretend. B, argue that whether or not means the same thing. What is? Oh, wrong one. Oh, and C, object to evidence of proper grammar. That's the type of frivolous legal argument lawyers are sanctioned for making in court. FYI, I will have a high school English teacher as a witness. Oh my.
Oh my God.
Are you fucking kidding me?
No. This is his MO. If he has to have I will have a high school teacher as a witness.
You gotta be shitting me.
Really?
I have a few more questions to add to the growing list that eventually will need to be responded to. If not here, see my rainbow list. Number 1. Should I speak louder when it's read? Has the Office of CDC ever received a complaint for prosecution based on the same charge? Specifically, a violation of Rule 1.5C because a fee agreement did not inform. There will be no litigation costs in CHRO. Number 2. If number 1 is no, has the Office of CDC ever itself prosecuted? Oh, yes.
Oh, my God.
Prosecute me.
He was that guy in high school that sent notes and said, will you go out with me?
Yeah.
Scratch and draw the little box.
Yeah.
That's where he got the boxes from.
Right, exactly. Hey, Megan's favorite bullet points. The square ones.
That's where he got them from.
That's where they came from. Clear back in high school. Where was I?
No, it was elementary school, I think.
Probably.
It's because Fred didn't pay any attention to him in the shower.
I'm pretty sure it was probably high school still, because I think even in grade school we were like, yeah, this is just dumb.
College.
Yeah.
Will you study with me? Will you be my study partner? Check 1 for yes, 2 for no.
Where was I? If number 1 is no, has the Office of CDC ever itself prosecuted a lawyer based on this charge? I.e., after the ACDC formulated it, sound like Doug is doing. Does OSBC ever prosecute? God, I feel like I need antibiotics or something. Does OSBC ever process grievances under 2-32A2? I.e., does it ever summarily dismiss a grievance without referring for a PC investigation? Oh my goodness, so many words. Maybe this isn't for you, but for Mr. Bowler. If so, we'll of course be requesting data and documents to see what the practice is and the nature of those that are dismissed. Number 4. Does It's torture for her because her husband's sick, so she can't be loud at all.
Oh.
Does OCDC ever move to dismiss under Rule 11? Oh, there's the big one again. 11A, A1. I.e., does it exercise independent judgment whether there is a basis for pursuing a charge? Oh. Or does it always come up with some charge to prosecute regardless of whether it's part of the underlying grievance?
No, it just always comes up.
Oh my God, how much more? Okay, we're almost done with this rambling. Okay. Stamina. Anybody got any Viagra? What guidelines are there for an ACDC to search for evidence of a violation? Does that even work for speaking? I don't know. A violation, when is it not supported from the grievance and PC decision? Doug made clear that he has and intends to use something big. A fishing license. Oh.
So big. Oh. My fish is bigger than your fish.
We're doing some catfishing. But does it have to be somewhat related to the grievance? Or is there no limit to his imagination and what he can do? Oh, I'm sure there's plenty he can do. Which of you is the final authority and decision maker on this? Who's going to spank me the hardest? Is it Doug's call, or does Brian have to grant permission to use the big leather whips? Doug, I authorize you to prosecute a 26-year lawyer with a clean record for this. To what extent is Brian in the loop on Doug's actions and statements in furtherance of this prosecution? I look forward to your responses to these and other outstanding questions I previously raised. That's not the only thing. Best regards, Bruce Matzkin, Escuela.
Killing me, y'all. Oh my God. This is so beautiful.
Oh my
You're only
God.
doing this because you're racist.
I'm racist. I feel so racist right now.
Oh.
It reminds me of In Living Color. Men on lawyers. Oh, hey, that sounds good. That's better than just being on films.
Okay, we gotta stop breaking the chat for a second. All right, this little gift right here came in from Karen Segner, and thank you very much, Karen. I'm about to open this thing up and see what we got.
While you do that, I'm gonna stretch my throat a little.
Faster.
It's getting all crampy.
Oh my gosh. Oh, and there's even a nice little letter in here. Well, thank you so much. What is that? Oh, it's a okay. Box tour. That's all. So much strength behind it. It says, Shizzy, sending you some coffee. Oh my gosh, Bear Lake.
Yeah.
I got some Bear Lake Coffee Company coffee.
Oh.
It is parallel red fire heritage grain estate barrel aged reserve El Salvador Pacas natural.
Wow.
So that's that right there. From a local shop in the town I'm working. They opened a year ago. Caleb roasts small batches, so it's always fresh. This is from barrels that have previously had whiskey in them. Oh, that's nice.
Oh, hey, that might be kind of interesting.
I also sent Megan, Mo, and Tug some. Oh, I was supposed to be quiet about that. Thank you so much. Thank you so much. I appreciate you, Kim. That's awesome.
Out of the bag.
I love it. That's so great.
Well, I'm glad you all enjoyed it. Megan, I hope I didn't make you pee yourself. Sorry about that.
She probably woke up her husband. Well, they like it when you're loud, girl. Don't you know? Emma, excuse me while I get a new change of underwear. Holy shit, that was hilarious. Oh, you should see our son.
I think that's one of the longest rants I've done in that voice.
It was so beautiful. Oh my God. Inspired by a celestial navigation space princess. Crazy old fart. Oh my gosh. I got a buddy of mine that does really cool car stuff. It's a Dirty Old Man's Garage. He is awesome. And he does crazy stuff. Thank you so much.
Oh, wait a minute. No, we talked to him one time. Yeah.
Yeah,
he's cool.
Yeah, he's really good people. One of my favorite peoples locally that I would hang out with in a absolute heartbeat, just because he's just that kind of guy. Damn, I almost cut myself. Says he put the knife away. Put the knife away. Well, and of course, now here is the respondent by Butler. No, this is more Bruce. Dear Mr. Staines, as a supervising attorney, you have responsibilities for the conduct of your subordinate. AC/DC's still a great band. I again ask that you call me. Just call me or email me with the time when you'll be available today so I may call you. Oh, let me call you. Call me. Call me anytime. Otherwise, please email me confirming your office will be filing a motion to dismiss.
The PC decision said that the SGC panel was accepting that there would be no mention of costs. Yet ACDC's Butler's specific charge is the exact thing the panel said it was not finding on the not mention of cost.
Can your office revise something like this after it's been explicitly rejected on a basis for PC?
ACDC Butler added words or not to rule to fit his charge.
Does ACTC have the authority to revise the language and meaning of rules of conduct?
Your office has instituted a special policy for me of only written communication based on what ACDC Butler describes as the nature of my communications.
What specific nature of communication is he
You're-
referring to and singling me out for this special treatment?
I'm so entitled to
Can respond nature of communications as meaningless.
Your
office.
background blocker is kicking in and it's cutting that out.
Oh, damn it.
Yeah. Sorry.
Sucks. What specific nature? Better?
Yeah, when you sit back like that, I think it's better.
Is he referring to singling me out for this special treatment? This is certain to come up, and I'm so entitled to know so I can respond. Nature of communications is meaningless.
your office motion for dismissal can and should state as follows. Whine, bitch, and moan. As you know, any disciplinary proceedings is a serious matter. The source of major stress and time consumption and can have major detrimental effects on a lawyer's livelihood if public discipline is imposed. I have tried numerous times to prevail on your office and ask you, the supervising attorney, to take into consideration the effects this is having, and will have on my practice, my family, my peace of mind. Like the little piece. As ACDC, great band, Butler continues to misguidedly try to harm my livelihood and reputation with nonsensical charge. He is a first-year ACDC, great band. I'm flabbergasted that you have sent him loose on me and that he's conducted himself the way he has, all after me, and that you have ignored it and me. The longer this continues, the greater harm to me from the conduct of your office, and the failure of your office not only dismiss clearly baseless grievance complaint, but even to give me repose of knowing what the final charges will be, or to afford me the courtesy of a phone call. Call me. Call me. I would like to make a motion to Yamaha do that every time he reads Bruce.
Oh my God. Well, it's his turn. Response
It's
January
either
4th.
going to be that or Peter Lordy. Should I try out Peter Lordy? Or should I
Oh
go?
gosh.
Or should we do men on lawyers again? I don't know.
Oh my gosh. Thank you so much. This is just you and Yamaha Biker killing it, laughing my butt off. Well, that's not bad. Killing it and making.
Fine.
You know they love it. They love it. They're just so enthralled by how well you do that voice.
I know, it just comes so naturally. I don't know what to
I
do.
know it does, doesn't
It
it?
does.
It's just so special.
Yeah.
You know, you get that nice warm fuzzy feeling, and then you just get it.
I know.
You feel like you want to get a good rub
I get
down.
myself all excited. I've never asked why you're out, or why you don't call me when you're out, or why. Oh, wait a minute. I don't think that's what this is. That's another made-up thing by you. I've only hoped to speak about this and have it resolved as soon as possible. 5 times your email auto reply pushed back. I like the pushback. Your return date. From what appears, you programmed it especially for me. I knew I was special. Like the special no phone policy. to avoid my legitimate, relevant questions. You just like it when I chase you, don't you? You're not sure what my issue is. Neither am I. No one's quite sure what my issue is. You can't be serious.
Serious.
Seriously. Regardless of whether you're out of the office or not, your response demonstrates you are perfectly able to conform. You will file that. Oh, Rule 11A1A. Wait a minute, A1. Whatever, just gets bigger. Motion,
bigger,
given that you have no basis for the charge you've articulated. That you feel my emails seeking to resolve this extremely upsetting matter or harassing, but fail to consider the effects of what you're doing to my life and livelihood, despite that you obviously have no basis. Says it all. I'm getting faint again. Wait a minute. You place an attorney with a 26-year clean. How many times are you going to say this? It's ridiculous.
Well, he says it as many times as he needs to. He's got to say. Because he's been clean for 26
that 11-inch
years.
thing or whatever that rule is. Under a month-long investigation based on ridiculous charge, one the PC was explicitly not based on, in which you altered the language of the rule to fit it all in, while threatening more charges that you have not even conceived of. Just make up. Lie to me, Pinocchio. Lie to me. You lied to me. There is no rule. It's men on lawyers. Lie to me, Pinocchio. You lied to me that there's no rule enabling an ACDC to seek dismissal. You institute special policies restricting my abilities to communicate. Oh, whatever you do, don't tie my hands. With your office about this, then ignore my relevant questions. Then program a phony auto replay to avoid me. To avoid the appearance you're ignoring my emails and requests for calls like the naughty little teenage girl I am. You seem to believe you're unconstrained by any standards governing your conduct as an ACDC, and that you have complete authority to upset the practice and life of an honest lawyer. Honest lawyer! That one tickled a little. For what reason you so Where was I?
Determined.
For what reason? Oh, yeah. For what reason you're so determined to harm my reputation? Well, there's got to be a reputation first. And record with this nonsense. I do not know. I really look forward to the peace of mind of knowing this will be subject to another 11A1A1A, however much bigger it's going to get, motion. Best regards, Bruce Matzkin, Escuela.
I'm not sure what your issue is, sir, but I'll return to the office when I do, and I will contact you when I can. Why I have been out of this is none of your effing concern, and when I return will be determined not by your needs with respect to this grievance. That I have gone so far as to respond now is only so that your happy ass would consider leaving my freaking office alone in the meantime and cease the harassing emails. Regards, Doug Butler. And this is from Bruce.
Oh my God. Excuse me, as his supervisor, you can and should intervene, okay? Is there a reason why the auto reply stating he is returning January 9th did not come in response to the email I sent from a different address? Why is he ignoring me? I feel left alone and vulnerable out in the dark.
Attorney Matzkin, Attorney Butler, he's scheduled to be back in the office on January 9th, 2023. Your file is being handled by him, and I'm in not a position to intervene in your matter.
Wait a minute. Are you Rogue Mama? Are you fucking kidding me? This moron posted this shit on Facebook?
Yes.
Holy shit.
Yeah.
Dude, you need to find that fucking horse and have it kick you in the fucking head again. Oh, it might just set you right.
Oh my god. Please, the host and the guest to state filings again. My goodness,
Oh my god.
We here have so much fun. You have no ideas how much fun we be having. We've been having
All
so
about
much
the humor
fun.
and parody. That's right.
Yes. That you don't
just like to have
understand.
fun.
Just like Bubbles never understood in the first place that Chinky Eye Joe is my friend. Chinky Eye Joe is like good friend of this round eye. And Chinky Eye Joe know more about the Bubbles than Bubbles know about himself. See, you understand? My friend Chinky Eye Joe. My friend Chinky Eye Joe. He know everything about you. He know where you live. He know what you eat. He know what your feet smell like. Chinky Eye Joe know everything. Oh yeah.
Well, it seems ACDC Butler's auto reply about not returning until January 9th and 5th. And wait a minute, why are we going backwards? Well, you got to push into it. It's for me only. A special no phone policy. And now, a special auto reply, apparently intentionally misinforming me. He remains on break. Oh, he just keeps lying to me. All this for not writing. There'll be no costs. Miss Larson, is Mr. Butler back at work or not? Is this me again? Oh, it's me again. Now he's out until the 9th. It's the 4th extension of the date of his return to office. Mr. Staines, please call me. Thank you. I would appreciate it if Mr. Staines would call. You don't want those stains on him. Today. Bruce Matzkin, Escuela.
This is from Leanne Larson.
Well, he's expected to be back on January 5th.
Oh, Miss Larson, don't you lie to me. I know you're lying to me. I'm going to scratch your eyes out. Mr. Butler's auto reply originally said he would be returning December 27th, then December 29th, then January 3rd, and now January 5th. Wait a minute, where'd the 9th go? I wonder if you might tell me the actual date of his expected return. I don't think this guy can count. I would be happy to speak to Mr. Staines, yourself, or any other ACDC in lieu of Mr. Butler. I don't want to speak to that little bitch anymore. During his extended absence, best regards and best wishes for 2023. Bruce Matzkin, Escuela.
From Butler Douglas. I will be out of the office until Thursday, January 5th, 2023. In the meantime, should you need immediate assistance, contact first Assistant Chief Disciplinary Counsel Leanne Larson, who you just spoke to. Douglas H. Butler, Assistant Chief Disciplinary Counsel, State of Connecticut Judicial Branch, and so on and so forth. If verification of the contents of the email is required, please request a hard copy version.
Oh.
Exhibit
I like it when
8.
the copies are hard.
Respondents, January 4th, 2023 at 10:40 a.m. Email to undersigned. Checking the auto reply. That's it. Checking the auto reply. Exhibit 9. Respondents, January 20th, 2023 email to Butler Douglas. And this is from Deuce again.
Gentlemen, I plan to call your office at 10 a.m. Unless I receive response before then, asking for a different time or informing me you will not be taking the call and ignoring me. Don't you ignore me, Dan. I'll put a fucking bunny rabbit on your stove. As I have stated in prior emails, don't fall out of your chair. I invite you to, you don't have your helmet on. I invite you to record the call and use anything I say on it in the SGC hearing if you feel it's of some value for that purpose. This is in response to you placing a no phone policy on me due to some yet unexplained nature of prior communications. When I call, I will be recording you. In every facet. Video. Voice. Oh, wait, he didn't say that. If and when you answer and if you ask me not to record, I will cease doing so. Pinky swear. I will cease doing so before we begin substantive discussion. Your choice. Just like in the dungeon room. You suggested I engage counsel. I did. Expensive. Wait a minute. I am expensive? No, I did. Expensive. And now
No, he did. The council gave me a back rub and he rubbed me down. He rubbed oil all over me. Do you know how much that oil costs? Olive oil is not cheap.
Wow. And now you claim there's some appearance requirement before responding. You won't speak to me. You won't answer my questions. You won't answer my calls. I ring the doorbell and you leave me out in the rain. And now won't respond to counsel I engaged at your suggestion. In the absence of an email response beforehand, I look forward to speaking when I call at 10 a.m. Best regards, Bruce Matzkin, Escuela.
God, Aspen folded too. God,
Oh my God.
God. Oh God.
Nobody else is going to hear this, right? This just goes away, right? This
Yeah,
is
it
just
goes-
between
goes-
us, right? Okay.
Just
All right, I wanted to make
totally
sure.
between
Okay.
us. Just,
Yeah. Phew.
just you, me,
I
and
thought it was
Chad.
gonna-
Just the three of us.
Yeah, just those of us right here.
10. Get this shit. This is from Tamara to talk. I don't know. Taco Manskin. I don't know what the name is. I'm hard at. I can't really read it.
Tamale.
So
You got Escuela.
And
What are
tamale.
tamales.
Well, tamale. You often don't get an email from tamale. Why is this so important? Just emailing. Also from my wife's account, in case you didn't see the one from me. Nah. Thanks, Bruce Manskin.
Nah.
Got him. I broke him. He broke his mic. I love it. I got him. He's crying now. Oh, God. That was beautiful.
Oh.
Oh, oh my God. I have to sit here and square. Solo practitioner Bruce Manskin is very worried. Oh, we're gonna have to do a reading of these. Not tonight, but we'll do a reading of these.
Holy
God.
Jesus. This keeps going on. Oh my God.
Oh, we're only on exhibit 13 and page 47.
Oh.
Yeah.
I
And
may
then
actually
he
turn gay
complains.
before this is over with.
Oh, and then of course
My wife's gonna be so pissed at me. Why are you talking like that? Like what? This is me. Hear me. See me. This is all because of Bruce Matzkin Escuela.
Oh God. Oh. So this is from Bruce again. Oh. I'll do it for you.
Oh, I
Thanks.
can do it. I don't care. You'll go ahead.
Okay. Thanks. I have
I presently have no intention of filing my own grievances. I have fulfilled my duty and filled it so hard under Rule 8.3. I just want to get to Rule 11 again. I have made clear my availability for more information, including written evidence. If you don't want or need additional details or written evidence, I can provide it as long as you request it for more support for a referral. I think you've had enough for that already. But if not, you can let me know. I'll just climb right up on top of it and you get all that you need. Best regards, Bruce Manskin. Best regards, Bruce Manskin. Christopher Slack did write to attorney Manskin. If you want that one. This is
hey, I could do a normal voice on this one.
Yeah.
Thank you for your email. If this office makes the determination to refer your material to a grievance panel, you will be notified. If not, you may still file a grievance complaint of your own if you choose to do so. Sincerely, Chris Slack.
Christopher Slack, First Assistant Bar Counsel, Statewide Grievance Committee.
I think I felt my testosterone level go up a notch.
Mr. Slack, I'm CCing here my counsel and disciplinary counsel, given the the proceedings against me. Get them right up against me. Thanks for that confirmation. I'd also appreciate knowing whether I'd be referred to for investigation so I could expect to be contacted. In my case, on March 2nd, email was too sparse. If referred to an investigatory panel, as you explained, would be the protocol. They will learn of the subject attorney's sabotaging his client's settlement, sabotaging his client's appeal, removing co-counsel's appearance against his client's written directions, then filing to withdraw his own appearance as a threat to this here client, blackmailing his client for additional fees, and I prefer blackballs instead of blackmailing, providing false inflated costs to manipulate and overcharge the client, blackmailing the co-counsel, threatening grievances. I can't get those big black balls out of my mind. Threatening grievances to get co-counsel to free entitlement. For all I know, he may have already done so, and you're not telling me. Malpractice which crosses over the realms of misconduct. Specific actions that would support charges of misconduct for more egregious, I think that's egregious, but I like engorging it, than anything than the 5 matters that led to his suspension last summer. All that can be established through written communications, court filings, and the client's account of phone communications, having fulfilled it. My obligation under that big Rule 8.3 in light of disciplinary counsel spanking me hard, abusive prosecution of me. I like abuse. I am concerned about whether your office's involvement in initiating me to that proceedings will prevent an objective consideration of what I'm bringing to your attention. An attorney, so well known to you from recent disciplinary matters committing more serious misconduct, as clearly implicates his honesty, trustworthiness, and his fitness. So fit. I'm available for any SGC investigator to call me. As co-counsel, I have first-hand knowledge and written evidence, the e-dockets of cases he's involved in as party of counsel. I'm going to turn all his shit in, contain the identities of people likely to be willing assistance in documenting this misconduct. He was involved in it the whole time. He continues to abuse the courts by suing people vexatiously out of retribution for filing grievances. See my e-docket. Notwithstanding the proceedings against me, I hope you'll take appropriate action in response to a man as best regards. Toodles, Bruce Manskin, Esquire. Christopher Slack wrote. This is Christopher Slack. Keep your manliness up.
Oh, you want me to do that voice? Well, I was going to try out another one. Our office has received your email and its attachments. Thank you, Chris Slack.
Christopher L. Slack, First Assistant Bar Counsel, Statewide Grievance Committee, 100 Washington Street, First Floor, Hartford, Connecticut, 0106.
From Bruce Matzkin.
This is so dumb.
I know. Oh my God. Mr. Slack and Miss Rowe, that gray affidavit was post-suspension. The other one was prior, but I don't know if Karen Dambiozzi ever saw it. These are just 2 examples from the e-dockets of several lawsuits in which he is a party, always self-repped. There's an abundance documentation and contact info and filings on these dockets for people who would assist any investigation or action by authorities. These affidavits are not matters I'm involved in. I was not aware of these large things until myself began looking at these, what I like to call dockets and flings. Flings. I was looking at these dockets and flings recently. Such large dockets, lots of flings. I would provide first-hand or maybe second-hand, maybe a little mouth action. It undoubtedly reflects on his fitness, but conduct occurring in a case we've been co-counsel, astounding conduct that should have repercussions. You can hear those repercussions all up and down my spine. I contacted you extremely.
Ooh, you making my pumpernickel tickle. Mm-hmm.
I contacted you extremely reticently, given what your office and office counsel is doing to me. They don't use any lewd. I'm targeted for made-up nonsense. Like, who can wrap their ankle around their neck twice?
Ooh. Ooh.
But this lawyer is truly a menace, yet I have to worry about what someone might do to turn this all against me.
I like it when they're all bendy like that.
I nevertheless decided to contact you because I take my ethical duties very seriously, and I haven't been able to duty in a while. Best regards, Toodles, Bruce Matzkin. Postscript, I'm attaching an unrelated item to conflict post. All you gotta do, don't mind the white stain. It's 2012. Your office initiated this investigation.
I swear it's just marbling.
Well, he wrote an article called Robitis. No misconduct was ever charged based in my exercise of free speech. This post is on my Facebook page. I'm aware it's more than 6 years ago. Not the point. Oh my God. Just saw a super chat. Emma Washington. Oh my God, I'm saving the stream for the next time.
I need cheering up. Yeah. I'm going to have to definitely go back and watch this one just to see your guys' reactions. Because we're doing this shit. I only catch it intermittently. And I know I'm pronouncing it as Squela, and I can't remember what the other one is. Squella, I believe, is for the death. Well, yeah, because it's playing off the ESQ, right? For the S.
Yeah.
I mean, it makes as much sense because his career is pretty much dead.
Isn't
anyway,
Esquila?
So. Yeah,
an extra squealer?
Death notice. Yeah, why not? Makes about as much sense.
Oh my God. March 22nd. 30th, 2023, an email chain between respondent and statewide bar counsel Christopher Slack, first assistant bar counsel Elizabeth Rowe, attorney Donato Rinaldi, and the undersigned. From Bruce. Go ahead.
Listen, one more time, bitch. From March 29th. For context, the other lawyer to whom it's written, DB, issued a check in all 3 names, okay? 2 lawyers and their client. The subject attorney is demanding DB exchange it for a new check, cutting me out, so he can steal the legal fees I'm owed. I'm not cheap, you know. I don't work for free. You can't rough it off me. As he has made explicitly clear in written emails. He's threatening DB that he will take appropriate action if DB does not do as he demands. I like a strong, demanding man, but still, within 5 days. He was informing DB that he would be coming to DB's office today to return the check. I didn't know if he did. This is ongoing, by the way. When do you think you'll be looking into these materials and take action in response to active written blackmail, of which you are now fully aware, by a lawyer known by your office of many previous naughty things and grievances filed by his clients involving dishonesty? Best regards. All the best. Bruce Matzkin, Escuela.
Bruce Matzkin says next on the 29th. Swallow.
I gotta stretch it out. Okay. Attached are today's grievance threats by the attorney. Another one against me. Go figure. Everyone hates the pretty girl. 16th? And now one against another lawyer. All to achieve the aim of enabling him to steal money from the proceeds of a judgment. He has determined what? Oh, he has demanded. There he goes, demanding again. Lie to me. I drive from Boston to Stamford to endorse the check after having written that he will not pay the legal fee he owes me from it. I have, of course, refused to do so. I don't know if he is truthful about having already filed a grievance against me or what he would base it on. Feel free to let me know. And also whether you'll take action on the serious misconduct I have brought to your attention by this attorney. Thanks. Bruce Matzkin, Escuela.
And also on March 22nd. Please replace the prior email with this one, which has a corrected statement.
Oh, Jesus.
Oh, my God.
Mr. Slack et al. Oh, you little bastards hiding in the background. Attached are numerous threats of grievances to blackmail me and my client by threatening to, don't withdraw too soon. That's not. See February 25th. Rule 8.3. Oh, it's still pretty big. A. Prohibits threatening grievances to leverage settlements of a civil dispute. This lawyer is ongoing to victimize the clients because he will not enable her to be paid, and it's blackmailing her for fees in a separate case. I have fulfilled my duty under the 8.3a, and it doesn't require me to back out. To file a grievance. I just push right into it. I urge you to refer this for investigation without delay, Mr. Man. If you will not, please acknowledge my report under Rule 8.3a of misconduct that raises substantial questions as the lawyer's honesty, trustworthiness, and fitness, and please acknowledge your office in choosing to forego actions in response to it. Best regards, Bruce Matzkin, Escuela.
He just doesn't stop.
It's like
email after email after email. Oh my God. Oh,
does it really, at this point, does it really matter how I pronounce it? It's all ridiculous. I don't care.
My God. Oh my God. Well, from Bruce, so glad to know how urgent you consider this. How ridiculous. And then, of course, Christopher Slack responds to Attorney Manskin.
Oh, yes.
Yeah, yes.
Oh, no. I'll do my other one. We are in receipt of your emails. Please know that our office is in the midst of moving from our current temporary location here at Hogwarts on Washington Street to our permanent location and the rubber room on Asylum Avenue. Accordingly, we are unsure of when we will have sufficient time to review the material you have submitted. Sincerely, Christopher Slack.
From Bruce Manskin.
To explain, the obtained retainer agreement is a typical one where a lawyer has ongoing monthly fees. Payment that, if missed, entitles him to withdraw from the matters, even if they've collected thousands in monthly fee payments over the course of months or years without having spent any time on the case or anywhere near the time to justify the number of fees collected. If you look into it, look deeply into it, I think you'll find common theme in numerous of lawyers' cases and many clients similarly milked. Milked. And abandoned. Yeah, they just drain him dry. The lawyer also includes a contingency fee of 1/3 of the amount of his client's mortgage balance or something. I'm waiting for any indication as to whether the report I made pursuant to Rule 8.3 is going to be forwarded this investigation. If not, I'd like to understand why. Best regards, Bruce Manskin. Wrote from USDC lawsuit.
Christopher Slack writes,
I don't know. But, thank you, Attorney Matzkin-style. Where is my Hermione Granger? This man is giving me a headache. I need a release.
and of course he complains he has not going to make a grievance. And then Christopher Slack says, thank you for your email. And then, of course, Mr. Slack, I'm CCing here my counsel, disciplinary counsel, given the pending proceeding against me. And thank you for the confirmation. I'd also like to appreciate knowing whether I'll be referred for investigation, so I should expect to be contacted. In case my March 2nd email was too sparse or referred to an investigatory panel, as you explained, would be protocol, then they will learn of the subject attorney sabotaging his client's settlement, sabotaging his client's appeal, removing co-counsel's appearance against his client's written directions, then filing to withdraw his own appearance as a threat to the client, blackmailing his client for additional fees, providing false inflated costs to manipulate and overcharge. Actually, I read what the filing was, and the attorney was removing himself because Bruce kept calling the person and telling them not to pay the other attorney. That's why. Yeah, just yeah. That's why he's going off on all this shit. And then, of course, he finishes. And speaking of finishing,
I don't even want to know about that. All right.
There's only one finishing move that we can possibly have, and that's this right here.
It is about time. Let's break this mother down. With Shizzy, Whiz, Nut.
Here we are again. Open letter. When Bubbles met the bar and lost. Or the curious case of the Connecticut crybaby who thinks due process is a hate crime. 2. Anyone with a pulse. CC, the judiciary. BCC, every paralegal who has ever cleaned up Bruce Matskin's mess, including his mother and his shitty little diapers. Subject, Bruce Bubbles Matskin, unfit to practice, but perfectly qualified to star in his own meltdown. Let's skip the pleasantries. Bruce Matskin is what happens when a mediocre lawyer discovers social media and decides that the rules of professional conduct are optional if you scream loud enough. Oh, And boy, does he like to scream in that little dungeon. And thanks to grievance complaints filed by the Connecticut Office of Chief Disciplinary Counsel, we finally have a public record confirming what anyone who's watched his antics already knows. Bruce Bubbles Matzkin isn't a misunderstood solo practitioner. He's a walking ethics violation with a Gmail account and a martyr complex, flailing his way through the legal system like a toddler in a pantsuit. Or a hooker during Fleet Week. And thanks to the Connecticut Statewide Grievance Committee's 13-page roast session, grievance complaint number 22-0301.
Just in case you want to look it up.
Yeah. We no longer need to speculate. We now have documented proof that Bruce Matzkin's favorite legal tactic is weaponized narcissism. According to this official record, and I use the term official because it was filed by actual lawyers, not your cousin Karen on Facebook. Bubbles spent the better part of a year carpet-bombing disciplinary counsel with emails, rants, Facebook posts, and bizarre conspiracies. Not to argue law, not to defend himself, but to whine, deflect, and publicly melt down because someone dared to suggest that maybe, just maybe, he's not the legal genius he thinks he is. No shit. This man is not a lawyer. He is a liability in a suit jacket. Let's break it down. This isn't about simple ethics misstep. This is a 13-page indictment of a man who thinks the rules of professional conduct are just suggestions, and that the disciplinary system is a deep state conspiracy designed to stop him from winning imaginary arguments with himself in his inbox. The complaint outlines, in painful, hilarious, and thoroughly documented detail, how Matzkin, acting as his own attorney, because of course he did, launched a one-man psychological warfare campaign against the Connecticut disciplinary apparatus, including its bar council, grievance committee, and apparently the basic structure of grammar itself. He didn't just respond to the complaint. No. He exploded all over it. Repeatedly. Publicly. Which is just wrong. Pettily. And in writing. Wouldn't that be considered indecent exposure? Over 100 emails sent to disciplinary staff, most of which had the professional tone of a guy live tweeting his own arrest. Public Facebook posts where he doxed his own prosecutor's LinkedIn profile while accusing them of making up the charge. Accusations that disciplinary counsel was altering the meaning of words to frame him. Because apparently, whether now means whether or not. And that's the hill he chose to die on. A claim that the rules don't require him to say, there will be no litigation costs in his fee agreement. And that this, wait for it now, is an abusive grammar trap laid by evil prosecutors.
Evil prosecutors.
He even emailed his wife's account to test whether an auto-reply was real or some kind of anti-Matzkin psyop. Let that one sink in. This is a man who believes out-of-office replies are being weaponized against him. Paranoid much? And yet, he wants to be taken seriously. The same guy who told the Office of Disciplinary Counsel, excuse me, I invite you to record the call.
Call me.
Damn it. Don't ignore me, Dan.
Oh, no.
Bruce, no one wants to talk to you. You're not John Gotti. You're a suburban employment lawyer who thinks Wordle is a legal brief and that every court email is part of a deep state smear campaign. Rule 4.4a of the Rules of Professional Conduct prohibits lawyers from using tactics that have no substantial purpose other than to embarrass, delay, or burden others. That's not a guideline. That's literally Bruce's playbook. He wasn't even defending himself. He was retaliating, spamming inboxes, posting Facebook rants, accusing state officials of targeting him because they wouldn't bend the rules to his liking. And irony? This all started over a $500 fee dispute. This wasn't a death penalty case. This wasn't a massive fraud. This was a fee agreement that might have been vague. Instead of resolving it like an adult, Bruce declared legal jihad on the entire state of Connecticut. And when they asked him, repeatedly, to stop clogging their inboxes with unhinged walls of text, he doubled down. And like he so often does, just backed right into it.
Just so hard.
Just
Don't lube it.
pushed right into. This guy is this guy who says things like, "I'm being prosecuted based on grammar error. I'm being prosecuted because I didn't say there would be no cost on a cost-free case." No, Bruce. You're being held accountable because you won't shut the fuck up. You won't follow rules. And you can't stop embarrassing yourself, you fucking mental midget. Let's talk about his favorite move, playing victim. Bruce's idea of defense is crying about his 26 years of a clean record, as if that grants him immunity from the basic requirement of writing a competent fee agreement. Then when that didn't work, he started attacking the disciplinary council's resumes, calling them small claims lawyers, and marking their careers while himself being an ambulance chaser, while simultaneously begging those same people to withdraw the charges. It's not legal strategy. It's narcissistic rage in a suit. And make no mistake, this wasn't isolated. It's a pattern. Matzkin didn't just target one prosecutor. He unloaded on multiple bar officials, committee members, journalists, and yes, even his own co-counsel. He threatened to expose others, accused people of misconduct for not helping him derail his own case, and claimed to be the victim of a vendetta while all they asked him to do was button up his trench coat and stop running around flashing people and comply with the basic rule of lawyering. He accused Assistant Chief Disciplinary Counsel Douglas Butler of making up the charge. Caps were his, naturally. Suggested auto-replies were customized just for him, and demanded hearings be canceled because, well, he felt persecuted by proper grammar. Yes, grammar. Oh, that pesky grammar. This genius actually accused disciplinary counsel of altering the meaning of the word weather to railroad him. But he likes getting railroaded. And when that didn't work, he started emailing from his wife's Gmail account. Apparently getting it confused with her G-string. Like a sketchy teenager grounded from his own computer. Here's the punchline. Bubbles did all of this while claiming to be the real victim of abuse, conspiracies, and systemic harassment. All because someone filed a grievance about his fee agreement. Not even a good one. Just vague. That's it. And for this, he declared war on punctuation, court rules, and the Connecticut judicial branch as a whole. The grievance committee didn't need to exaggerate. They just quoted him. The raw material was already insane.
Oh, he likes it raw.
Oh, yeah. It's like watching a Picasso poo artist at work in a padded cell. You don't get to claim you're the victim when you're the one lighting the matches in a fireworks factory. Final thoughts from planet Earth. If Bruce Matzkin ever tells you he's being railroaded by the system, well, just look at how long the train is. Just know, the system didn't come for him. Oh no. He volunteered to run in that train.
Long enough.
He ran it right there. He ran that train whole hog, screaming with joy.
But they didn't come for him. Come for me.
Covered in self-righteousness and LinkedIn screenshots and OnlyFans. Well, anyway, demanding everyone recognize how brilliant he is. This isn't persecution. This is a mirror. So let's set the record straight. Bruce Matzkin is not being silenced. He's being tuned out because he won't stop treating due process like a Reddit thread. He is not being persecuted for grammar. He's being sanctioned for acting like an unstable Facebook uncle with a bar card. And most of all, he is not a misunderstood legal mind by any stretch of the means. No, just a poor child that was kicked in the head, allegedly, at one time by a horse. He is a cautionary tale. Don't get too near the horse. A loud one, with footnotes and Google Docs. Bruce, you're not Edward Snowden. You're a mid-tier Massachusetts attorney who got caught acting like a jackass in Connecticut. Let's not sugarcoat it. The man cannot function within basic professional norms, cannot accept responsibility, and cannot shut the fuck up long enough to let anyone else talk. Every time someone tries to address the issue, he responds like he's auditioning for a Netflix docuseries titled Persecuted, the Bruce Matzkin Story, as told by Bruce Matzkin. Or maybe as the fluffer in a Red Shoe Diary. So if you're wondering whether anything he files in any case anywhere should be taken seriously, here's your answer. No. Because once you've accused disciplinary counsel of running a personal grammar-based witch hunt, let me rephrase that. Because once you've accused disciplinary counsel of running a personal grammar-based witch hunt while simultaneously emailing under aliases to check if auto-replies are real, you forfeit your credibility forever. If there's one thing the rest of us, lawyers, judges, clients, spectators, can take away from this flaming wreck of a disciplinary proceeding, it's this. Don't be Bruce. Don't pull a Matzkin. Don't gaslight your regulators. Don't send 100+ emails screaming about grammar. Don't make your meltdown public and then cry when the public laughs. And if you ever catch yourself writing an email under your wife's name because you think the Connecticut bar is out to get you with fake auto-replies, well, take her high heels and panties and bra off and go look in the mirror and remind yourself you're supposed to be a man. Close the laptop. Seek help. Bruce, you're not being silenced. You're being held accountable. There's a difference. And unlike you, the rest of us learned that in law school, not in a Facebook comments section. Sincerely, Shizzy Wisnut, Supreme Court of Common Sense, Chief Counsel for people who are sick of your bullshit, proudly serving the anti-bullshit department since day one, and wobbling my way through my days while I laugh, wearing my helmet and Velcro shoes, and as always, and anon, your daddy. Wow. That was,
It is about time. Let's break this mother down. Wit, shizzy, whiz, nut.
Wow. Oh my goodness. That
Oh my
was,
God.
yeah, that was quite the flaying, wasn't it? Oh.
Yes, slightly. It was quite fun.
Wow.
Yama, you weren't
I could
expecting
see.
that
I could
tonight, were
see.
you?
No, I was not. I was not expecting that one at all. I could see
Well,
why you
just-
said it took you a little while.
Well, and you have to understand that you know the emails that Shockett showed and those pleadings. Once you see that pattern, you realize that this is more than likely what Shockett has been dealing with every single day that Bruce has been involved in this case.
Oh, sure.
You know, this wouldn't be uncommon. He's trying to litigate it with opposing counsel, and Randy's like, I actually have a law practice with multiple clients. Where are you finding time to send these emails and harass me over crap that doesn't need to be harassed? Because he stated even in one of his pleadings, you know, I have this isn't the only email that I have from him. This is just a small amount of them where he misbehaves like this. But according to Bruce, the rules don't apply to him.
Oh yeah, yeah. It's everybody else. Yeah. Well, I mean, just like in those ones, what is there? Just a couple of the ones that we've seen where he doesn't even give him a full 24 hours as required.
Oh.
He goes and files this shit like at the last minute virtually, or just a few hours before midnight or whatever, and then wants to turn around and whine, piss, and moan and bitch about it. I mean, yeah. It figures why he fits in so well with Lynette Preston. I mean, they both have a shitty ass track record with lying and bullshitting and deceit and blah 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 blah.
Yeah,
so,
yeah, and he feels
and
for
victimhood.
I mean,
yeah.
Maybe he's looking for a new wife. You know, I don't know.
oh, please,
Match made in hell.
No.
Could you imagine that being your neighbors?
I wouldn't even wish that on him.
I don't know. I don't wish it on anybody. I don't wish either one of them on anybody. Oh,
And this is someone who I probably wouldn't piss on his face if it were on fire to save his life.
probably not. Do we know the outcome of this disciplinary? In all actuality, no, because that's kept closed. As far as I know, he was supposed to have a hearing on May of 2024 in regards to this. What the outcome was, don't know. Don't know. I'm sure somebody out there does, and I'm sure there's more information. If you dig deep enough, you can find a lot more information about this disciplinary hearing. But me, I got so much other time to do other things whenever I'm not worried about him. But yeah, it would be interesting to find out. It'd be interesting to find out. He had to take a course. That's what he says. But see, you have to understand, because it's confidential, all those kinds of things aren't released. He might have said that he had to take a course.
Yeah, I'm not exactly gonna take it. I wouldn't believe him or the useless turds if they told me day was light and night was dark. So
no, because the useless
I
ones,
don't even know. I'm not even gonna believe in the idea that that whole thing is even completely shut out. I kind of have an idea that Connecticut might be kind of waiting to see what's going on during this whole fiasco and see what his behavior is. And who knows? We'll wait and see.
Well, yeah, Megan said that. I don't know. Megan might have information. She might have looked it up and found out that information.
Yeah, I don't know. I'm just saying, maybe, could be. Who knows?
Hey, all I know is he can do him. And I've said this before. He's the one that reached out and wanted all of this. He wanted all of this read. He wanted to expose all of how bad he was mistreated.
Yeah.
Yes, it's crazy. But tomorrow, and again, I do want to thank Karen so much for the coffee beans. Thank you very much.
Yeah,
Karen.
that's pretty
That was
cool.
absolutely. And I will be using these on the morning streams, and then I'll also thank her again on the morning stream, and probably have some of this. Yeah, not in the morning because we have a full container of coffee right now, but whenever I do get to them, I will be thanking Karen for it. I heard it's not finished. Yeah, I've heard all kinds of stuff. I don't know.
Yeah,
and there may be other disciplinary actions that are going on that are related to this case. I know that there's another case that hasn't been concluded yet involving him and the attorney that he was ratting on. I mean, I've like I said, I don't really spend my whole day just looking up shit for bubbles. I just it really doesn't affect me that much. I mean, it affects Jeremy how
right,
but it's one of those. I thought it was a good reason to show cause. What was the question? How has the disciplinary action panned out? Like, what happened in the disciplinary action? That's what everyone was curious for, and I don't have an answer because it's closed as far as closed. It's closed. It happens behind closed doors. What happens behind closed doors stays behind closed doors. Don't ask, don't tell.
Yeah.
But you know, I do have a feeling that there's something coming up. Where is it? Because I've got this. I want you guys to hear, and I think it's pretty good. Present, share the screen, and let's see. I want to share this, and then we're going to hide it by putting us back up here, and then let's play this because I think this is pretty good. Tell me what you think, chat.
Yeah, this one going out to Bruce the Deuce. You ran from the fire, now the judge is holding the torch. Let's get it. Yo, Bruce hit the court like he ran the town. Long filings, big talk, trying to shut it down. Said I fight for justice, but when he got real, he ghosted like smoke. Now the judge got the wheel. Didn't show up, didn't hold that line. Dropped a week notice trying to buy some time. Claim fear, conflict, the same old pitch. But it smelled like panic, cause Bubbles ain't built for this. You said you'd ride, now you slide. That's a weak foundation. Filed and lied, then you cried. Ducking cross-examination. Now the court got receipts and your name on the list. Should've shown up BBB, but you dip like a bitch. Withdrawal notice more like federal fade. Left your whole team stranded, no debts paid. Withdrawal notice can't run from the flame. You alleging in excuses, a legal shame. Now the court hit Randy with 4K flat. 2 motions, no substance, imagine that. So what's BBBO for a stack of junk? 10 grand, maybe more, depends how deep the trunk. You cried, Parliament, like it meant defense. But the judge ain't dummy, saw past pretense. You played the martyr, claimed arrest was near. But the only thing threatened was your whole career. Yeah, you said you'd ride, now you slide. That's a weak foundation. Filed and lied, then you cried. Ducking cross-examination. Now the court got receipts and your name on the list. Should've shown up BBB, but you dip like a bitch. Withdrawal notice more like federal fade. Left your whole team stranded, no debts paid. Withdrawal notice can't run from the flame. You alleging in excuses, a legal shame. You left your clients hanging, donors looking sick. Promised to fight, then you bounced real quick. Second lawsuit waiting, judge still on the bench. And Bubble still hiding behind weak defense. This ain't TV, it's a federal ride. And you just got tossed off the side. So write your next motion, make it long, make it loud. You're still just a soy boy in a courtroom crowd.
Yeah, withdrawal notice ain't protection. It's an obituary. The judge has lit the fuse, and Bruce, he's about to be lit like fireworks.
Yeah,
that was
it was kind of, I kind of like that. It was kind of catchy. Yeah. Kind of bobbing along a little bit there.
somebody's finally catching up.
What is that? What the heck is wrong with this?
Husband's going to bed early. Try not to start. He wants to know it's so funny. Oh,
I know.
right there. Thank you so much, Ben Truth.
I have a feeling Megan was, based on what she was saying, the way she was acting, she was, I think, genuinely in pain tonight. She could.
She couldn't laugh.
But the ASMR voice.
Oh,
Her husband should be sick more often.
So
Kidding,
Deuce
I don't
has
wish him to be
Connecticut.
sick.
It says Deuce has a Connecticut bar hearing at the beginning of May. He said that he might give up his Connecticut license, all because he refuses to take a 3-hour class. Now, I know that he had one in May of 2024, but I don't know of one.
I got another theory about that too, and you and I have discussed that behind closed doors. But I'm going to keep that card close to my chest.
Yeah,
And
we're supposed to keep. We're supposed
We'll
to
wait
keep that.
we'll wait and see what happens. Yeah,
We're not supposed to talk what goes on behind closed doors.
I know.
You know, it makes Diva jealous.
I know. She likes to cuddle with us.
I know she does. Everybody, make sure that you I've pinned Yamaha's channel right there.
Thank you.
That's Yamaha's channel up there. The very top. Go and give it a nice little tap, just like you want to tap Yamaha. You know, you get to go
His
and give him a
stories,
little
It's
tap.
got nothing to do with this crazy stuff.
Exactly. He tells stories. You get to hear this
Just tell
lovely
stories.
voice the whole time. So go and check him out, everybody. Show him some love. Show him some love. And everybody, I will see you guys tomorrow. And tomorrow it will go over to a Rumble exclusive. It's going to be tight. It's going to be an interesting one. So grab your sandals and
Are you talking about in the
prepare
morning,
to-
or are you talking about for in the evening?
in the evening. Tomorrow
Oh,
night will be.
okay.
I will start over here, but then towards the end, I will kick
Bump
it over
over.
to Rumble for Rumble only.
Okay.
So most of the stream will be here, but I've got probably a good half hour or so, maybe longer, that will be on the Rumble side. What time on Rumble? Well, it shows up the same time on Rumble that it shows up here, but I will start out here and I'll have the link so everybody can go check out Rumble tomorrow. But it streams, it's multi-streams on both this Rumble, so you can check it out then. And yes, I will see you guys in the morning. Have
Thank
a good
you
night.
all. Have a good night. Bye.
Oh, you thought I was done, bless your heart, but I'm still living rent-free, it's a work of art. Call me daddy, call me nut, call me the goat. You're paddling upstream while I'm running this boat. You say, I don't care, yet you're glued to the screen. Caught up in my glow while you stay unseen. Your shade's like a breeze, it's barely a draft. Meanwhile, I'm the Picasso of roasting your ass. You say you're over me, oh how cute, but here I am, still the star of your loop. You're my biggest fans, don't even deny, so grab some popcorn when daddy goes live. Live. Call me daddy, yeah, shout it loud. King of your thoughts, I'm making you proud. Papa Nut, Shizzy Daddy, headline act. Your background noise, and that's just a fact. Let's face the score. You hate that you love me, but you keep wanting more. You're like a dog chasing cars, you don't know why. But here you are, barking while I touch the sky. Your comments are gold, such comedy gold. Who hurt you? Oh wait, it's me, I'm told. You're keeping tabs like an unpaid intern while I'm cashing checks. When will you learn? Your timeline's a shrine to every move I make. I'd say thanks, but you're a nasty skank. Oh, Shizzy's washed up. Yeah, sure, Jan, yet here I am, the centerpiece of your plan. You hate watch my stream like it's Oscar night, but guess what, kiddos? I'm still shining bright. Call me daddy. Send in your bread, I'm still rent-free in your effing head. Papa Nut, Shizzy Daddy on your brain. I'm your mental landlord, you can't complain. Let's keep it real. You hate that I'm for like half a week. But daddy's too spicy, you can't look away. I'm the train wreck you need every single day. So while you're out there with your plastic clout, I'm here sipping coffee watching you freak out. You're irrelevant, wow, what a take. Now go rewatch my vids while I count how much I make. Like count how much I make. Call me daddy, yeah, own it now. I'm reading your brain and you don't know how. Pop a nut, shizzy daddy, let's set the bar. I'm the constellation, you're a burned out star. Embrace your role, cause I'm the main character. You're just an old ragged ass, burned out troll. So that's your bedtime story, kids tucked in sweet and snug. Shizzy daddy's forever, you lose and you're stuck in the mud. Now say goodnight to Papa Nut, your mental plane. Oh wait, you will see me tomorrow's. Agenda will see me tomorrow, same obsession, same effing thing.